Right now, thousands of people who applied for an Australian visa are sitting in limbo, checking their IMI account every single day, refreshing, waiting, wondering if something went wrong. And what nobody is telling them is that in May 2026, the rules of the game have quietly shifted. Processing times have changed. Priorities have changed. And if you don't know what those changes are, you could be waiting far longer than you need to. Or worse, you could be about to make a decision that sets your entire application back by months. Welcome to Aussie Visa Info, and today we are going deep on exactly what is happening inside the Australian immigration system right now in May 2026. Not last year's data, not estimates pulled from outdated forums. What is actually moving, what is stalling, and what you personally need to do about it before this month is over. Stay with me until the very end because the single most important piece of advice in this video comes in the final minutes, and it's something almost no one talks about. Let's set the scene first. The Department of Home Affairs is operating in one of the most complex immigration environments Australia has seen in years. On one side, the federal government has committed to reducing net overseas migration from the record highs of 2023 and 2024. On the other side, Australian industry is still screaming for skilled workers in healthcare, in trades, in aged care, in agriculture, in digital infrastructure. These two forces do not naturally coexist, and the tension between them is being felt directly in processing times and visa grant rates across multiple subclasses. What this means practically is that the department is being extremely deliberate about which visa categories get prioritized and which ones sit in the queue. And unless you know how that prioritization actually works, you're essentially flying blind. So let's talk specifics. The temporary skill shortage visa, subclass 482, is one of the categories where there is genuine momentum in May 2026. Employer-sponsored applications with complete nominations and solid labor market testing documentation are moving. The medium-term stream is seeing healthier processing windows than it did through much of 2025, particularly for occupations on the core skills occupation list that align with the government's workforce priority areas. If you're in this category and your paperwork is solid, there is genuine cause for optimism right now. But, and this is important, if your sponsoring employer's accreditation is not current, or if there are any discrepancies between what's on your nomination and what's in your employment contract, your application will not move. It will sit. Case officers are not picking up the phone to clarify minor inconsistencies the way they might have in a lower volume environment. They are simply moving on to the next file. That is the reality of the current system, and it is unforgiving. Now let's talk about student visas, subclass 500, because this is where Aussie Visa Info has been receiving the most questions this month, and for good reason. The post-2025 reform environment has made the student visa pathway significantly more scrutinized than it was even 18 months ago. The genuine student requirement is not a box-ticking exercise anymore. It is a substantive assessment, and case officers are trained to look for coherence. Does this person's study plan make sense given their background, their financial situation, and their long-term goals? Applications where those three things don't align clearly are being flagged. And here's the part that should concern you if you're in this position. Being flagged doesn't always result in an immediate request for more information. Sometimes your application just sits in a secondary review queue for weeks before anything happens. If your timeline is tight, if you have a course start date approaching, this is not a theoretical risk, it is a real one. The partner visa story in May 2026 is both honest and sobering. Subclass 820 and 801 onshore applications are moving through the system, but median times remain extended. Offshore applications, the 309 and 100 pathway, continue to be among the most time-intensive in the entire system. The most common reason strong applications still take a long time is not complexity, it is allocation. When caseloads are high, even well-prepared files simply wait their turn. There is no hack that bypasses this. But there is something you can do to make sure your file doesn't create its own delays. And that is making sure your evidence is so complete and so clearly organized from day one that a case officer can open your file, understand your relationship immediately, and move forward without needing to request a single additional document. Here's something that Aussie Visa Info wants to flag specifically for anyone on a skilled independent or state-nominated pathway right now. We are just weeks away from the end of the financial year, and that timing matters enormously in the skilled migration space. Invitation rounds under Subclass 189 and the state nomination programs under 190 and 491 are in their final weeks of the 2025-26 program year. Some states have already hit their nomination caps in certain occupation categories and have quietly stopped accepting expressions of interest. If you have been sitting on a completed expression of interest in Skill Select, waiting for your point score to climb, or waiting for the right moment, that moment might be right now, or it might have already passed for your specific occupation. This is why checking information that is current to this specific month matters so much. A point score that would have received an invitation in February may not receive one in May if the demand in your occupation category has surged. And there is one more thing I want to address before we wrap up, something that genuinely affects a significant number of applicants and almost never gets discussed. If you are currently onshore in Australia on a bridging visa while your substantive visa application is being processed, your work and study conditions on that bridging visa are directly tied to the conditions of your previous substantive visa. Any confusion about what you are and are not permitted to do while you wait, whether that is working full hours, changing employers, or traveling internationally, can create compliance issues that reach back into your visa application itself. This is not a minor administrative footnote, it is something that has derailed otherwise strong applications, and it is absolutely worth clarifying with a registered migration agent if you have any uncertainty at all. The Australian visa system in May 2026 rewards preparation, precision, and patience, in that exact order. Preparation means your application has no gaps. Precision means your documents say what they need to say, clearly and completely. And patience means understanding that even a well-prepared application operates within a system that has its own rhythm, and your job is to make sure nothing you do slows that rhythm down. Here at Aussie Visa Info, that is exactly what we're here for, keeping you ahead of the system, not behind it. If this video gave you clarity on something you were unsure about, please like it right now. That one action helps this channel reach other people who are sitting in the same uncertainty you might have been in before you pressed play. Tell me in the comments what visa you're waiting on and what country you're applying from. I genuinely want to know, and it shapes the content we make next. Subscribe to Aussie Visa Info if you haven't already, and turn on that bell notification, because in an immigration landscape that changes this fast, being even 2 weeks behind on information can genuinely cost you. Don't let that be you. I'll see you in the next one.